While Diddy's lawyers have been waiting for the judge's verdict on whether this third attempt at bail will be successful, the U.S. Department of Justice has now filed their declaration saying that Diddy has already broken the rules again. Welcome to Popcorn Planet. I am Andy Signore, and the judge instructed both sides to make a letter explaining obstruction, etc. And we've gotten both letters in. I'm going to give you a summary of things. As I expect in the coming day or two, we are going to hear about this bail verdict. Now, here was the U.S.'s letter talking about how they basically wanted at the hearing, the court requested they address whether the defendant's conduct constituted obstruction, et cetera, et cetera. They went in to sort of describe what that actually is of obstruction, including to obstruction of justice, traditional ground of pretrial detention of courts. When the Bail Reform Act does not define obstruction of justice, district courts have interpreted obstruction in the pretrial detention context broadly to include willful actions that jeopardize the integrity of judicial proceedings. Many of the defendant's obstructive acts, discussed further herein, easily fall within that broad characterization and show a persistent, brazen effort to improperly interfere with this criminal case. So then they go through a lot of these incidents, more specifically the racketeering conspiracy offense in count 1 alleges act of obstruction as set forth. 2016, the defendant bribed security officers with $100,000 in cash to destroy evidence of that Cassie video while in the hotel for a freak-off. The defendant bribed $100,000 for the video to go away. In doing so, the defendant relied on intermediaries to reach out to security staff and help carry out the cover-up. The act is alleged as part of his bribery racketeering conspiracy predicate. After victim filed one in 2023, a lawsuit alleging other things in the freak-offs, etc., the defendant made multiple efforts to interfere with victims and witnesses by feeding these individuals false narratives regarding the defendant's criminal conduct. For instance, the defendant caused intermediaries, former and current security staff, to repeatedly call a former employee, employee 1, who had witnessed firsthand the defendant's actions of the victim. The intermediaries told employee 1 in sum and substance what she had observed was a normal relationship. Around the same time, and as highlighted as prior hearing, the defendant recorded 2 phone calls with a different victim in which the defendant attempted to feed victim 2 a false narrative regarding victim 2's involvement. So basically, he's calling them out and saying, no, this is what you saw, right? This is what you saw. And then they're calling other victims to say, actually, this is what we saw. So it's a new whisper down the lane sort of version of things, and potentially money exchanging hands as well. He also apparently deleted messages between himself and key witnesses, including a key grand jury witness and victim 2 in the criminal case. One of these witnesses was a worker who participated in these and received a grand jury subpoena during the investigation after defensive counsel represented unequivocally at the prior bail hearing before Judge Carter that the defendant would not reach out to the grand jury witnesses. It became clear that the defendant had done just that. Phone records and electronic evidence show that the defendant contacted the witness repeatedly leading up to and after his appearance in the grand jury, and the defendant apparently deleted the messages from his phone. There were further communications and there were texts throughout this entire period. And it's interesting because we are apparently going to get an army of these types of people coming to go against him in the future days as this progresses. Now, again, more deleted texts. While in pretrial, the defendant used multiple unauthorized means of communication, which makes it difficult or impossible to monitor his communications. We talked about that through the Contact Me app, etc. What's so glaring, and this is what I was teasing in the beginning, he was still doing it. Now, counsel represented that he had stopped it, but he has continued to use it. Notice the stress there in the italicized. At least once to one other inmate, sending messages to a family member as recent as November 24th, which is literally yesterday. He did this yesterday. After his attorneys, I can assure you, he'll listen to me. He'll promise we won't use it. We know now that's bad. He did it yesterday. The hearing was Friday. He couldn't wait 2 days. This guy's a moron. While at the MDC, the defendant has instructed family members and third parties to contact multiple potential victims' witnesses. The defendant has provided these instructions to others by using unauthorized means of communication, which makes it difficult to monitor, et cetera, et cetera. So look, intimidation, that's where I wish we'd get a little bit more specific as to what's actually being said. He orchestrated a social media campaign around his birthday. where he was making it clear that this was going to help to convey the jury. So they're claiming he wanted to know the analytics. I honestly don't have a problem with that. I don't think that's obstruction. I don't. He's a celebrity. He's allowed to post posts. Now, those posts can be used against him, but he wasn't pinpointing a specific jury member. So I do think some of this is a little not as extreme as the other. The fact that he can't literally just follow the instructions is pretty shocking, I gotta say. Under Rule Criminal 23, parties prohibited from release or authorizing the release of non-public information or opinion which reasonable person would expect to disseminate by means of public publication in connection with pending or immediate criminal litigation with which they are associated, if there is a substantial likelihood that such dissemination will interfere with a fair trial. That's, I guess, what they're trying to claim this Instagram post was, but I'm not seeing it. The government also deemed that the whole bail package was insufficient, citing Combs' history of using his wealth and influence to manipulate others, including private security personnel who they're claiming is going to help, but not. They argue that no combination of conditions can guarantee the safety of the community or ensure the defendant's appearance in court. There's a lot more, and we can digress and go through these more on tomorrow's live, but I wanted to give you sort of the quick summary. So here's what Diddy's response was. Diddy's response came back. The defense argued that his speech is protected by First and Sixth Amendment rights. The defense claims the government's arguments that asking his children to post birthday wishes on Instagram and that he is not entitled to publicly express his opinion, that his prosecution is racially motivated, are quite simply an unconstitutional effort to silence him. The defense distinguishes Mr. Combs' speech from the types of speech that courts have previously deemed prejudicial, such as comments about witness testimony or attempts to influence potential jurors. They argue his statements are protected political speech and criticism of the government. The party seeking to justify a speech restrictions bears the heavy burden of demonstrating in advance of trial that without prior restraint, a fair trial will be denied. The record must show the specific words have an extraordinary power to undermine or destroy the efficiency of the criminal justice system. Anticipated speech about being a revolutionary or about a racist prosecution involves thoughts that this prosecution is politically motivated or that he is innocent of the charges against him, core protected speech. They argue that Mr. Combs' attempt to contact potential witnesses is protected by a Sixth Amendment right, his right to assist in his defense. They clarify that upon release, Mr. Combs will accept conditions prohibiting direct contact with victims or witnesses, but maintain that while detained, he has a constitutional right to work with his attorneys in reaching out to potential witnesses. While detained, however, and in the absence of such condition, the status quo remains that Mr. Combs has a constitutional right to assist his lawyers in reaching out to witnesses. We now await the response from the judge about whether or not Diddy will remain in jail or be at house arrest in his apartment in New York. So it's still up for debate. I honestly, I'm still shocked we didn't get one that day. And the fact that we didn't get some of the day does seem to imply that he could get it tomorrow or the next day is my guess. So we will keep you posted. We'll go live once we get the word or it's impending. So stay tuned if you haven't already. Hit that subscribe button, hit that bell for all alerts, smash that like button. Also, big news. It is already in the can. I spoke to Adria English. It is a really intense interview where a lot of people are doubting her and Misha. I wanted to have a fair, respectful conversation. Honestly, I'm still trying to sort it all out, but I wanted to be fair and give her the benefit of the doubt and have a conversation to hear her side of things, her defense to some of these accusations that are coming out there. So you're not going to miss that. We'll be dropping that tomorrow morning. Part 1 of that is tomorrow morning. So stay tuned, hit the subscribe. We'll see you with more soon. Thank you guys so much for watching here on Popcorn Planet.